Yes.
Grateful and not.
Criminal appeal, the appellant is in the jail. So kindly taken up next.
Which year appeal?
2024.
24 appeal.
The
He'll go to the consent bench. It is only old appeal.
I want to mention my criminal appeal number 121 1994. I'm supposed to file written note today. May I kindly be permitted to file on Thursday?
He is filing.
Okay.
Yes. You mention it?
This is
Is she mentioning? Yes, there is someone, Mr. Mahapatra. Yes, Mr. Mahapatra, are you mentioning?
29 taken up a Thursday after launch due to my illness. my lord.
29.
49, 49.
29 again.
Yes. Who was-
Thursday. It is 2000.
Okay, okay.
Again.
Yes.
Item 1.
Item 1 will be last occasion
Then, right.
call for report.
Other is the report, huh? Okay. Report was short. Okay. Okay. What was the report? Appellant number 3 has already undergone the sentence.
Yes.
Appellant number 2 is concerned, it appears that the court, he has taken custody, but when he was guaranteed to be mental health condition of appellant number 2
Yes, he
and
used-
period undergone.
Yes.
Let us
He
see.
used to remain absent from his house for several months and sometimes he used to return home and he used to become violent. But the family members could not produce any document to show that he is suffering from unsoundness of mind.
He used to remain absent from the house several months and sometime used to return home and he went somewhere and did not return and his whereabout at present is not known. The family member could not produce any document to show that he is suffering from examine the elder son of okay. That what his name is what?
Gurucharan Mahanto.
Guru Mahanto. Gurucharan Mahanto. Okay.
And so far as custody period of appellant number 4, Halku, is concerned,
Hmm.
he was all along in custody during trial. He was arrested on 11/6/1991.
11/6/1991.
6/1991.
Yes.
Date of judgment, he was in custody 22/1/1994.
94.
Thereafter, appeal was filed before this honorable court and this honorable court by order dated 6/4/1994 was pleased to release all the appellants on bail.
6/4
6/4/1994.
bail.
Appellants number 1 to 3 were released on bail except Halku.
Halku is the
Appellant number 4.
appellant number 4 is also on bail.
No. Your
Where-
Lordship may kindly see the order
No,
dated.
then what is the report then? He went, he is not.
He is appellant number 2, not Halku. Gurucharan Mahanto.
Oh, so Halku is 4.
Halku is 4.
So Halku is still in the custody.
No. It's released. He must have undergone the sentence, my lord.
The intergone might
That
be.
for that reason, jail authorities have stated that no record is available in
Might have
must have been
gone.
destroyed.
No, file done. File done.
And again, NBW was issued by this honorable court on 25/7/2014. He was apprehended.
Hmm.
Subsequently, again released on bail on 29/10/2014. And nobody pointed out that he has undergone the sentence.
So that's it. So, you said when NBW was issued?
25/7/2014.
NBW 20
5/7
25/7
2014.
14 and
Right.
arrested,
The arrest date is not there, but I could not
but released on bail on
29/10/2014 by this honorable.
2014. Bail.
Prior to that, no order is there. So he was all along in
He
custody.
might have already undergone.
Must have. Because by the 1994, he has undergone 3 years.
Hmm.
From 94 to 2014, no.
What is the
operator.
sentence, by the way?
Sentence is, my lord,
Okay.
What is the sentence?
sentence to undergo RI for 5 years, 304 part 2, and the fatal blow was given by Halku.
Halku.
Yes.
Stick on head. Assault by means of stick on head, land.
That is appellant number 4.
Yes. Only one.
Even if the appeal is dismissed, nothing is going to happen because
No,
they are
yes.
not going to be. What do you say?
No, appellant
Okay.
number two, my lord, so far as this.
Appellant number 2, Guru.
Guru.
So far as appellant number 1 died.
No, that's right. Appellant number 1 died.
Gurcharan Mahanta has undergone
Uh,
from 20 to 1, 1994.
Hmm.
He is in jail custody, released on bail on 27/4/1994.
so how much he has undergone, Guru?
He has undergone my lord.
A1, just tell me once again. A1 died, huh? A1 died. A2 arrested on
On 11/6/1991.
11/6/91 arrested.
Released on bail on 17/5/1992.
17/5/92 bail, huh?
Thereafter, from the 6/4/1990, thereafter, from the date of pronouncement of judgment, he was in custody.
That is
That is, my lord. 22/1/1994.
22/1/94.
22/1/94.
94 judgment.
Released on bail by this honorable court on 6/4/1994.
6/4/94 bail. Okay. This is A2. A2 means the how much this would be around 1 year here. And 1 year, 3 months,
Yes.
roughly
1 year, 3 months, 4 days.
4 days. 1 year, 3 months, 4 days. He's mentally retarded, huh?
Yes.
Retarded. Okay. A3.
A3
A3.
has undergone the sentences.
You tell me when he was arrested. 11/6/91.
1991.
11/6/91 arrested and bail by trial court
Well, my lord.
on 22/1/94.
92.
92.
17/5/1990.
Same A3 also.
All the three were released.
Okay.
on
17/5/92.
17/5/1992.
Okay.
Thereafter, from the date of judgment, he was
Same then. Same.
suspended.
Same, huh?
Yes.
Okay. Same. 1 year, 3 months. Okay. A4.
A4 is has undergone the sentence, my lord.
A4.
A4, my lord.
That's what you said.
Date of arrest is 11/6/1991.
11/6/94 arrested.
91.
Sorry, 91 arrested.
Alone in custody.
Arrested. And 22.
22/1/1994 judgment.
94 judgment.
And he was never released. His prayer for
Judgment.
bail was rejected by this honorable court by order dated 6/4/1994.
And he was granted bail on 6/4/94.
No.
Rejected.
Rejected
6/4/94 bail rejected.
by this honorable court. So he was
Thereafter, he might have already undergone and he was released. Already undergone. ठीक है. Now then, A2 and A3. Let us see. Concentrate on A2 and A3. Whether case is read out or not. This is the position. Let us see. A2, A3. A2 is Guru and
Yes.
A3 is Shambhu. Yes.
So far as all the allegations against F4. He has assaulted
Hmm. Yes. Who is the eyewitness? Who all are the eyewitnesses?
PW1 is the informant.
Informant, huh? Let us see informant, what he says. Informant. ठीक है. What does he say? Tarachan Monto. To put these land of from the Panchayati and Ignition. Madhu Monto alias Halku.
Appellant number 4. Gurucharan Mahanta, appellant number
Gurucharan.
appellant number 2.
Shambhu Monto, Tarachand and Sadhuchand came there armed with lathis also. Halku Mohanto dealt a blow on his lathi on the left side of the head of
Kruttivas.
Kurtivas fell down. And Hemanto Mohanto, and who was flogging the land, rushed towards Kurtivas. But Shambhu Mohanto dealt a lathi blow on the head of Hemanto. Who is the deceased?
Deceased is Kruttivas.
Kurtivas. Then Shambhu Mohanto gave a blow to only Hemanto. Hemanto is examined.
Hemanto, my lord. Yes, my lord. PW6.
PW6. Hemanto also fell down. Myself and Vasanto ran towards the place where the injured were lying. Guru Charan was holding an axe. Vasanto tried to snatch away the axe from him, and I broke the what is that?
Not legible.
Bow. Who is the son of Tarachan was holding, and snatch away the arrow. Arrow. Take a bow. That is bow. Arrow from him. The accused persons were still there on the land, and so on so. We brought the Krutivasa to the private doctors also. Then, insofar as Guru Charan is concerned, he has not given any blow.
No.
He was there. Insofar as Shambhu is concerned, he gave a blow to Hemanto. But Halku has given a blow to Krutivas, who eventually succumbed to death. This is what the story goes. And who all are the eyewitnesses? Let us see PW6. Come to PW6, Hemanto. Come to PW6, Hemanto. Let's see PW6. Two years ago, the Friday morning at about 8 p.m., myself and my brother Siris Mohanto were logging our land. My father Chaitanya was sowing the paddy in the land. That land is our land, and we were in possession also. So this is a Tony
Asu land.
And Vasanta Mohanto was with us. Srinivas was there nearby. Krutivas was also there nearby. Krutivas is nearby. These people were there in our land. At that time, Tarachand Mohanto, Gurucharan Mohanto, Shambhu Mohanto, and Halku Mohanto, and Uja Mohanto came armed with bows, sticks, lathi, and so on so. They attacked Krutivas. Halku had dealt a blow with a stick on the left side of the head of Krutivas. Krutivas fell down, lost his consciousness. I ran near Krutivas. Shambhu Mohanto dealt a blow with a stick on the left side of my head. Shambhu Mohanto. and I fell down. Chaitanya Mahanto, Basanto Mahanto came to save me. Basanto snatched away the tangia from the hand of Guru Charan. And what he says, tangia? No, one says, right, Guru Charan was here, tried to snatch away the axe. And that time, there was a scuffle. There was a scuffle between the Basanto and Guru Charan, and they fell on the ground. Chaitanya snatched the arrow from Urju. There was a scuffle between them, and the wife of Taracharan came to the spot, and she held Guru Charan and cut hold of the tangia with Guru Charan, so as not to allow Basanto to so. This couple has taken place.
Yes.
But it is attributed, Halku has only given the blow. Given.
Okay.
Yes. Who is the doctor?
Doctor is my lord, the PW4 is the doctor who examined the injured, and PW5 is the doctor who conducted autopsy.
PW?
PW4 is the doctor who examined the injured Hemanta, PW6.
PW6. Yes, Hemanto, PW6. PW6 examine. Right side of the head.
Yes.
Injury is simply in nature.
Simple in nature.
Simple in nature. Simple nature. Yes. Doctor. And 5 is another doctor.
Five is another doctor who conducted autopsy over the dead body of the deceased.
Yes, internal bruises, and he has examined who? Kurtivasa.
Death. Yes, deceased.
Deceased.
Only one bruise on the left temporoparietal area of the skull. That is the fatality.
Okay. Let us see the reasoning of the trial court. Which paragraph?
So, Lordship, may kindly see para 12.
Para 12, yes. The next point,
This.
which requires
Next
examination,
point, which
whether
requires
all the
examination
persons
to
should be
whether
liable
all
or
the
not.
accused person should be liable, or whether only accused also alias Madhucharan Mahanta and Shambhu alias Sadhucharan Mahanta would be responsible. It is stated by PWs 1, 6 and 7 that the accused persons came in a body to the land armed with deadly weapons, and one of them, namely accused Halku alias Madhucharan Mahanta, suddenly dealt a lathi blow on Prithivas, and then accused Shambhu alias Sadhucharan Mahanta dealt a lathi blow on Hemant Mahanta.
All this discussion he has done.
Yes.
So their action will be amount to their action. Will be amount to an action of the assembly.
Yes.
And each member of the unlawful assembly will be bound by the act. Therefore, all the accused persons would be equally liable for that is the logic. So 149 is employed.
Yes.
149 is employed. Therefore, this is what the logic is. What is the sentence then? Sentence to arrive for 5 years.
300 for part 2, read with 149 IPC. So far as 323, read with 149 IPC is concerned, sentence is 3 months. No separate sentence was passed on section 148.
Halku, how the state petition put it, the process of the land. Yes, sir. How will you get out of 149?
That the occurrence took place at the time of season of cultivation. And they are also going to land for cultivation. They are all belongs to one.
No, but the reasoning of the trial court appears to be correct in the sense they is employed 149. Because see, all the witnesses have said, particularly 1, 6, and 7, the witnesses have said that all of you went together to attack. So therefore, the trial court says that it is an assembly, unlawful assembly, which led to the free fight.
Yes.
So therefore, 149 is employed for the purpose of convicting you.
No, all the appellants belong to one family. And at the time of cultivation of the land, they are the farmers. And
You say you are trying to say it is a natural assembly.
my
It's not a unlawful assembly, natural
Yes.
assembly, because everybody was there.
yes,
Plugging for the purpose of plugging their land, everybody were there.
my
And the weapon, that's the logic one can think of. The weapon used by them is also natural weapon in the sense those weapons are used for the purpose of cultivation.
yes.
Not black tea.
It's not Lathi is used by Halku only. Halku used the lathi, but the other accused persons were holding the agricultural this, and this logic can be employed for the purpose of reducing their sentence to some extent. Because it can't be said to be a natural, can't be said an unlawful assembly. It is a natural assembly because all of them were together there. And they have not procured some kind of weapon for the purpose of committing the crime. These are the weapons used for the purpose of agriculture, plugging and all. So they were holding that. How do you say that? How do you react to it?
Misunderstood. So far as Halku is concerned, the
Yeah,
sentence
Halku.
So far as others are concerned, period already undergone since no overtake by except
Because
simply
see, so far as the Guru Charan 2 is concerned, he's already, I think, he's mentally gone. You can't catch him.
That's why I am making a prayer. Like the period already undergone. Halku has already undergone the sentence.
So the para 12 which we read,
Yes.
that we can interpret in that way, saying that it was a natural assembly, so it can't be said to be an illegal assembly. And the weapon carried by them are the weapons generally used for the purpose of agriculture. So they were not intentionally holding anything for the purpose of committing crime. So therefore, para 12 reasoning, although correct, but we can interpret that way.
Fine.
And already undergone. Okay. Okay. Let me give one. Okay. Yes. Okay, thank you.
Item 2.
Yes.
Yes.
Mr. H.S. Mishra was asking for adjournment in this matter only.
No. 22. 22.
92.
Government languages.
Sovrano Kuruk. Otherwise. Let's pass out, let us see. Let him come. Because Mr. H.S. Mishra was appearing. Let's see. Otherwise. Huh?
Report.
A report. Report was asked, sir. Report. Yes. A report was called for. Just check it up. The Superintendent of Police Bolangir is directed to inquire about the status, well-being, and the whereabouts of the appellant, and please report. No, 2023. So this is an order of 1/7/25. No, recent. No. The order dated 1/7/2025 and 3/2/2026 has not yet been complied by the state. Lieutenant Counsel for the state seeking the last opportunity. Last opportunity to obtain the report from the Superintendent of Police Bolangir. Release the matter next week, Thursday. Thursday, huh? Because the two opportunities given, many opportunities, two more than that. Bolangir. Today only you issued the notice. Okay.
Item 3.
Yes.
The report has been called for.
The report, you got report, yes. How many appellants are there here? One. Vikas Behra. Is working as a person to the order dated 1/7/2025 and 3/2/2025. The IAC Konika PS has placed on record Suvarnapura placed a police report dated 7/2/2026 in Intralia apprising this court that the sole appellant Vikas Behra is presently working as a manager in Star Health Insurance Company at Vargar branch. Vargar branch. In view of the aforementioned report, next. So, what about? Are you ready now? Huh? Huh?
So it is a conviction of total 10 years, Lordship, and
Sorry?
10 years total conviction.
So therefore, you have to be seriously argue it. Tuesday, I'll keep it. Next Tuesday. The appeal is ready for hearing. Release the appeal on next Tuesday. Yeah? Tuesday. It's made clear that no adjournment shall be granted. A report is taken on. Okay. Tuesday, no adjournment will be given. 97. Yes. Next.
Item 4.
Alive. Sole appellant pursuant to the order dated 1/16/12/25 and 3/2/12/25/26. A report dated 9/2/2026 by IIC Raidapur Police Station. I will place on record. As per the report, the sole appellant is surviving. The appeal is ready for hearing. Yes, madam.
1 week,
Huh?
Lordship, 1 week.
Ready to pay? Please see its appeal for final disposal next week. Yes.
Next week.
Next week. Okay. No. Next week it will be included in the this 24. Naturally. Yes. 5
Hearing.
hearing.
Item 5.
5. Yes, sir.
An application number for extension of time to surrender.
By order dated 22/11/2024, while 22, the petitioner was directed to surrender before the court on or before 5/12/2024. But for the reasons stated in the application, he could not surrender on time and seeking an extension. Time extended the out for the bill and it made clear that no further extensions are granted. Yes.
Item 6.
Another 15 days time can be. Yes. 6.
My lord, it's a formal amendment, my lord. Say the prayer portion.
What amendment?
My lord, khali PS case ta mention in the first prayer, first.
Hey, you have written FIR in Lakshminagar PS case number 19 of.
That was not mentioned in the first paragraph of the prayer. That only it's a formal amendment. That only might be incorporated in the
What are you seeking with? Question.
question, my lord.
Why this matter has come to this court?
My lord, it was previously heard before my lords. Hence, it has come upon before this bench.
Okay. The formal. Where is that application? This
My lord, two
flag F. Flag F. Flag
D.
P.
D for dog, my lord.
D. This application, application for amendment.
We'll file the consolidated within the course of the day, my lord.
The IA number 2001 of 2027. This is an application seeking amendment to the prayer portion,
My lord.
prayer portion of the petition, CRLMC.
First paragraph.
For
of the prayer.
the amendment short is formal in nature, therefore the state council is not seriously approving the same. For the reasons stated in the application, same with the allowed. Consolidated you have filed?
I'll file it within the course of the day. Within the course of the day.
Council for the petitioners shall file the consolidated petition, amendment petition during the course of the day.
My lord, can I
Release the matter for the.
My lord, can I pray for listing it on this week, my lord, so that it can be heard finally?
This week is Sunday is only available. Next week only.
Thursday.
Next week, Next
Next
Thursday.
week, what a
Yes.
date, shall we?
Yes.
Go date.
Yes, next.
Item 7.
7. Passover.
Item 7, my lords, I appear virtually, my lords. Plus before.
He's asking for Passover.
My lords,
Asking for
my lords,
Passover.
my
Yes.
lords.
Sant of Jari. Yes.
Item 8.
This case, your lordship had already heard and reserved it for judgment.
Hmm.
So, lordship remember because Innova, Toyota Innova, which was purchased. An FIR was lodged by one Ashok in the capital PS.
Judgment was reserved.
No?
Judgment was reserved.
Judgment was reserved. Then at that stage, another matter was by court add to this case.
Okay.
So your lordship referred the co-accused matter to mediation.
Mm-hmm.
Then, my lords, then your lordship released it because by then your lordship assignment changed.
Hmm.
So my matter also got, this matter also got released. Therefore, thereafter, the co-accused matter goes before Justice Mahapatra. Justice Mahapatra quashes that proceeding.
Then why this matter has
No,
come to me?
because Justice Mahapatra himself was appearing in 1 or 2 dates in this matter earlier. That's why this matter is specially assigned to your lordship by the erstwhile Chief Justice.
Okay, assigned.
This was assigned, specifically assigned. That is how it's there. The connected matter.
Now the co-accused, this thing is quashed because of mediation.
Some money was paid by the co-accused. Everybody paid some money, and then they have managed to.
What is the impact of this order insofar as this present petition? Devi Prasanna Padi, I think he is the man who is really.
Devi Prasanna Padi actually cheated. I was the innocent.
Have you seen it? He is the person he has done now. These are the bank people unnecessarily. They are the.
Actually,
Some you are away loan or something. Tata Finance.
Gave a clearance that the car is free for vehicles.
He is the main guy. This Devi Prasad.
So they have come to an understanding, and that is solved.
So what remains?
Nothing remains for me. My case was clear-cut case that your lordship, even on the face of that also, your lordship said I was this.
Is what I remember that.
Tata Finance.
What do you
say?
Just now I received.
I have paid off the Tata Finance loan to the last PI, no due certificate.
Let us see what is the. You tell the fact of the case so that he'll understand it. You tell the facts of the case.
Yes. It's the Ashok Kumar Dana.
FIR, you are reading FIR?
No, FIR. Copy of the FIR.
Where is that? Can you give me a copy? Annexure 1.
Annexure 1.
Have you filed translated copy?
I have translated copy.
Please give me that if you have.
I see Ashok Kumar Pali, agent so and so, 42 years of standing so and so. Like to inform, hereby inform that since Devi Prasanna Pali, son of Pitamba Pali, residing at so and so Sundarpada Airfield, had sold his vehicle. That is red colored Innova, bearing registration number OR028200 to my wife, Srimati Suchi Smita Das, for a consideration of 8,20,000.
Devi sold to Suchi Smita.
Suchi Smita, that is. The wife of Ashok Das for 8,20,000 on 29/5/2008. After that, the ownership of the vehicle was transferred to the name of my wife, Smita Das, and also registered in active Bhubaneswar. But later, I came to know that there is an outstanding loan of 8,33,900 from ICICI Bank Bhubaneswar on the same vehicle. But Shri Devi Prasanna Padi registered the vehicle in the name of my wife by placing forged NOC in the RTA. Bhubaneswar. I asked Devi Padi, why did you commit the fraud on me? I'm going to lodge an FIR against you. He said, if I inform the police station about such fraudulent manner, there will be more difficulty and the bank will take over the vehicle. And I, as well as my family, will be defamed. After that, Devi Padi and his father, Pitamba Padi, invited me to their home and said to return the money within 10 days and cancel the RTO registration certificate. On 12/3/2009, I returned the vehicle bearing registration number so and so, an original RC book to Devi Padi in presence of his father. However, when said Devi Padi to return my money, he did not give me. After 10 days, when I contacted his father, Pitamba Padi, who informed that he is unaware of the whereabouts of Devi Prasanna Padi, and he said not to come to his house again and again, and also not to call him. I went to the RTO Bhubaneswar to inform about the alleged forgery. That is when I came to know that the vehicle bearing registration number so and so has been refinanced by Tata Finance. And on Sushant Pujari,
you have purchased that.
And purchased the vehicle, and the registration has already been transferred in the name of Sushant Pujari.
That is how you are compliant.
Connection that I have. And
now Devi Prasad Padi's case has been caused.
Devi Padi's
he is the main guy who has done all these things.
And in the meantime, also Tata Finance also, I have repaid the whole Tata Finance. No,
you paid that. That part is also there. That part. You have. I think you have mentioned that you have petition.
Tata Finance, before selling me the vehicle, they gave me this thing that certificate that no, it's all clear. There is no
from all encumbrances.
No encumbrance, no hypothesis. So therefore, I purchased the vehicle
by availing loan.
By availing loan, and I paid back the whole loan. I'm a respectable businessman. I have nothing to do.
And what is the reasoning given by this on mediation report? It was sent to,
He took paragraph 5. On perusal of the mediation report, it appeared that both sides have agreed not to proceed in the criminal proceeding, subject to petitioner paying a sum of 2,50,000 to opposite party number 2 towards full and final settlement of the claim.
who is opposite party number 2?
That is that lady.
That's Susmita, Suchit
Causing the affair.
the affair.
It is also agreed that the opposite party number 2 shall not file any such claim or dispute before any other forum, and that any dispute with regard to the subject matter pending in any other forum shall not be proceeded with at the instance of opposite party number 2. This would possibly also compass the same affair.
In fact, it is quashed.
It was gone. The learned counsel for the opposite party number 2 files a memo which indicates that the above sum noted sum of 2,50,000 was already paid to opposite party number 2 by DD number so and so dated 28/11/25.
But see, the para 8, if you see, do you need further orders?
No.
Para 8, last line, just see.
Yes.
First line.
No,
Therefore, this court, in exercise of its inherent power, is inclined to terminate the entire criminal proceeding in GR case number so and so.
So technically, my lord, this
Technically, your case is also quashed. Okay.
My record for my sake. My
Give
safety
that,
sake.
give that translated copy. Send it.
For the sake of my safety, my lord, can make an order.
But it is, in fact, it is quashed.
But I need an order for my safety. I've been harassed and dragged through, and the case is pending against me. I've appealed.
But it is here in that order, it is not written. Qua this petitioner, nothing of that sort.
No, that is not there. Was against this petitioner. So therefore, Lordship may extend it to us also.
How many accused are there?
Only two accused.
So that I'll clarify that it is quashed, the entire case is quashed. So that another CRLMC will not come here.
Because I'm already on bail in the trial court.
Okay, I'll quash.
Cases.
Entire thing is quashed, unnecessary. The main accused has gone, everybody has gone.
The opposite party 2 is the wife of the informant. The informant has since died. So therefore, the opposite party number 2 is
It was referred to mediation by me.
Your Lordship.
But mediation report is not there, I think.
No, it's there in that court.
Can you
Dita separate hegala na?
separate? Can you give me the date in that matter?
Date is
Reference date. I'll find out. I'll find out the proceeding.
Mediation date 28/11/25.
325.
12/3/20. Oh, it's written there in the order itself.
Your Lordship's order. I can refer to mediation by what you order dated 12/3/25.
Okay.
And the copy of mediation is 28/11/2025.
Okay, very good. I'll do that.
A order is something.
I'll read it. Okay.
A file upon file 12 order.
Gotcha. ठीक है.
Mediation order
Okay.
28/11/2025.
Mediation report भी तो प्यार of case कर.
Okay, I'll pass.
Wait.
Take the button.
Your Lordship, my humble prayer, the item 4 was called, was here, our associate was here. The status report was called for, and the person is alive, but Your Lordship may also direct for a paper.
No paperwork. Take it from here.
From pen. All right.
Direction is also not required. You can get the pen drive and take it. Yes. Next.
Item 9.
Item 9, pray for pass. Maybe taken up after launching it. Because I sought for some instruction that will be.
The order is yet to be complied. It's 12/9/2023 order, my lord. Your Lordship's order. Your Lordship granted 1 month time to comply the order. It's a rehabilitation appointment. The husband of the petitioner.
She has been called for computer test, but she refused. And
Computer test is not.
as per my instruction yesterday, she has come and given the letter that I am ready to appear in computer test.
That is not correct.
Okay.
As per my instruction is concerned. So
Then
they will send
it
instruction.
would be complied then. It will be
Yes.
complied. Just ask whether that was the case.
Computer test is not necessary, my lord, because the rule does not provide so.
That's
So
a different story.
Once
That is a different story. I'm not
once you
going to-
comply the order and allow, pass an order appointing her as in a class group C category.
Which-
Thereafter, she can.
If she it is to appear computer test and she has given
Not
a
necessary.
Which was that order, according to you, is not complied?
12/9/2023 matter. See, rehabilitation appointment is the widow wife is the petitioner. 2018 husband died. The lordship page in my content petition page 33 your lordship, the operative. Sorry. 33. I'm sorry.
In view of the foregoing, I am.
26 madam. 26 your lordship.
Where the petitioner is reproduced above.
26.
It has to be allowed, therefore, the petitioner is disposed of with the direction to the to consider the case of the petitioner for giving an opportunity under RA scheme, so on so is demanded approval since the matter is produced. That is essential that the process is completed as expeditiously as possible, preferably within a period of 1 month also. It is only said that consider. It is only said that consider. They are considering. Let us wait. You
Consider matter, thereafter they prefer
See,
writ appeal. Writ
you-
appeal is also
you
dismissed.
should only aim at one thing, that he should get the benefit of this judgment.
Yes.
Let us wait.
Two, my lord.
I'll put it Tuesday. Let us and
Yes.
give concrete and file an affidavit.
File compliance appeal.
Compliance.
Yes.
Tuesday.
The lordship also specifically observed that the matter, since the matter is of the year 2018, so that is why lordship directed within 1 month will come.
See, if
Yes.
he is entitled to benefit of this
Yes.
judgment, you give it. Why unnecessary? No.
Then
Or the file
lordship may
compliance.
call it next week, file the compliance appeal.
Thursday I am giving you. At least say you let counsel for the state submits that you
This
file compliance affidavit next Thursday, next Tuesday,
Next.
compliance affidavit within this week. Within this week, release the matter on Tuesday, whatever date. 17th. 17th.
Yes.
Okay.
Obliged. Good.
Yes. Yes.
Item 10,
10, 94 matters.
Sixteen, 12.
Not coming. What is this? Really?
16/12,
What is the offense? What is the offense? What happened is Mr. H.S. Mishra is the lawyer. Somebody came from his chamber. He said that we have no instruction. I said that you appear as a Makishkuri. That's what I say. He agreed and now he's not coming.
Yes, sir.
Now, what is the offense?
Section 27, I am sad.
Sentence?
Section V1 XI SC and SC Act. Sentence is 451 2 years, 325 7 years and V1 12 5 years. And 27 arms act 7 years.
So then
Acquitted of the charge under section 376 acts.
call the madam. Madam, you assist the court in this matter.
Yes.
And I request one senior counsel also, because 7 years sentence. And you assist him. Huh? Maharaj. And primarily you have to do all the work.
Yes.
Mr. Maharaja will also be accompanying. Maharaj. See, on 16/12/2025, the counsel appearing for the appellant, Mr. Ganesh, from the office of the counsel appearing for the appellant.
Pardon me, I have 10 years of experience.
You have 10 years.
Yes.
And then you can do it yourself. Why? Since 10 years he has, why should then? Okay. And then you do it yourself.
Yes.
Appeared and submitted that they have no instruction from the appellant. Since appellant, this court requested the counsel representing the appellant to assist the court amicus curiae However, when the matter was taken up on the subsequent dates, none has appeared on behalf of Mr. Amaris Mishra, who was requested to assess the court in the capacity of amicus. However, in the subsequent date when the matter was taken up, none has appeared. None has appeared. Therefore, I appoint Madam Rakhi Mishra, who is present in the court to assist the court in the amicus. She is the registration. You can take the soft copy. Registry directed
Yes,
to
yes.
supply soft copy of the TCR and appeal paperwork to Mr. Rakhi Mishra. This is the matter for hearing Tuesday, next Tuesday. Okay, 94 matter, madam. I'll not give adjournment. Please do it. Prepare some note and come as you have been doing it. Okay. Yes.
Item 11.
11. B.S. Tripathi. Huh? On the request of pass over, otherwise I will appoint. He is not coming. Huh? Then we will appoint someone if he is not coming. Only go then. Give it to Maharaj. Give it to Maharaj. In this matter, in this the appeal is of 1990. None has been consistently appearing for the appeal. However, at one point in time, Mr. D.S. Mishra, counsel had appeared for appealing. Therefore, date of hearing, the state council has requested to intimate Mr. D.S. Mishra. Even after intimating Mr. B.S. Mishra regarding dependency of the appeal, none has appeared on. He has not appeared, or there is no appearance on his behalf in the court. Therefore, I requested Mr. P. Kumar, advocate, to appear and assist the court as amicus curiae. He is directed to supply the soft copy of TCR and paperwork to Mr. P.K. Maharaja. P.K. Maharaja. You intimate P.K. Maharaja. Take, yes. His name. So the name will be, her name also will be reflected, and the other name has to be removed. Yes.
Item 12.
Item 12. 11 appellants are there, madam. Item 12, 11 appellants are there. And
item 12, 13 can be taken up after lunch. Sir is on the.
After lunch, he will come. Mr. Dhol's office.
Whereabouts is also required because they have not mentioned the age, and as there are many of ages about more than 60 years, 65 years.
NCR has not come.
TCR,
NCR is also not come.
TCR is not there.
Last direction was to coordinate. What is the report? What is the report? Have the registry did anything?
Reports in letter.
Letter, where is that letter? Show me. Letter is gone.
Whereabouts?
Why this is happening? Letter कौन पठाई?
Madam, this is for the first time being listed. And
Whereabouts?
उधर.
Letter dated 282, dated 4/2/26.
Even after search for the case record investigation number so could not be traced out. till yet.
No,
So I am unable to. Huh?
Y1 plus Y1.
No, Y1 only I am seeing. 4/2/2026.
so on an average.
তার আগুন ভিতর দিয়ে হিতরা উঠে সেটা। See, who is this man? Yeah? See, earlier, just see, earlier
Yes.
on 8/12/2025, the additional, first additional district and sessions judge Khurda has given a report saying that the case record is not traceable. Okay. Again, I passed an order on 3/2/2026. What he did is, same thing he reiterated and sent me.
And maximums are more than 80 years. The persons, because they have not.
So then without trial court record, how will you decide?
Only judgment is there.
It's a shame. Despite repeated directions by this court, the neither the soft copy nor the hard copy of one trial court record has been placed on the court. Earlier on 8/12/2025, the first additional district and sessions judge Khurda has intimated this court that the record pertaining to ST case number 4/50/307 of 1995/1992 could not be traced out. Therefore, the record has not been transmitted to this court. This court again reiterated the direction by the order dated 3/2/2026. On 4/2/2026, a report has been submitted by the first additional session judge, which is the repetition of its earlier letter dated. It is which is verbatim repetition of the earlier letter dated 8/12/2025. It appears that at the office of first additional district session judge Khurda, no sincere efforts have been made to trace out the record, and the letters are being simply reiterated, stating that the records are not traceable. In view of this sorry state of affairs, I am constrained to direct the district and sessions judge Khurda to personally look into the matter and submit a report forthwith. Least the matter on Tuesday. Let him, the district judge give it. What he did is he has written see, on 3/2/2026 I passed the order. On the next day, on 4/2/2026, next day. That means he has not traced the record. Next day, same letter, earlier letter, he copy paste and send it. Let's see. At least 2-3 days thereafter, you could have sent. This order be communicated to the Registrar General of this court, who shall personally interact with district and sessions judge Bhubaneswar and give a separate report to this court. Let both the report come from Registrar General also. Yes.
Item 13.
Parted. What time?
The previous the matter has been partly out by the Mr. Das Parida.
You tell with clarity. Why are you so scared? You tell what with clarity. What do you want? No. You tell. You are telling something else.
Yes, sir.
You are telling something else. You tell what
No,
exactly.
on the last division, the Mr. Das Parida is arguing. And
It is a parted matter.
Yes, Lordship.
So he will come at 12 o'clock or 2 o'clock. When?
Actually, no, he is not any instruction. He will come or not. That.
Is he there in the court?
No, Lordship.
Today he is not there.
No, Lordship.
Has he instructed you that seek an adjournment or anything of that sort?
Pass it over. He asked me to.
He is not there in the court. What?
No, no, he asked me to pass over, sir. Lordship.
He asked you
Till,
to okay, pass over. Huh? Pass, okay, pass over. Okay. Yes. 14.
Item 14.
Because the problem is these people are unnecessarily stuck, na? See, everybody is handling one or two matters. Because of you, these people are whole day sitting here. They can do some other work.
Last time my lordship already had this matter and
Why don't you do one thing? Instead of dividing the matter amongst many lawyers, one or two lawyers can sit here. See, one matter he is holding, two matter you are holding.
Pune Metro.
That's the problem. Because these people are stuck here unnecessary. For two matters, they'll keep waiting whole day. And you keep on asking adjournment and no, they, at least you are free, na? At least you are free in the morning, at least. That's what I was telling him.
First item with the
At least they would have hearing हो बाकी लोग free है ना? Unnecessary समस्त को बसी की फायदा.
18, 24, 24.
Go and ask your senior and whether he's ready today to argue or not. You come and inform so that at least they will be free. Okay, go and tell him come. I will pass it over. Yes.
Item 14.
14. TP Rai.
Council personal.
Report and Mekishkuri was appointed.
ACD doesn't perform the type. ACD doesn't perform number. I'm not sure.
No, what is the when we have engaged him?
Previous MIT.
No, what is the use? Just see how many dates of hearing he has not appeared. He is not appeared. See on 8/2/2024 he didn't appear. Again on 18/12/2024 he didn't appear. Again on 3/4/25 he didn't appear. And 1/7/25 he didn't appear. And then 10/7/25 didn't appear. What is the use of this kind of immigration? I don't know all the dates. All the dates. None has appeared on the appeal. Though the was appointed when by the order dated 18/12/2024, SCD Das was appointed by this court to as an amicus curiae to assist the court. However, on when the matter was taken up on 3/4/2025, 1/7/2025, 10/7/2025, nobody appeared on behalf of the amicus on behalf of the appellant. Even the amicus curiae has not appeared. Therefore, this court feel it appropriate to discharge the appointed amicus curiae and appoint. Then again, Mr. Raghuda, you are coming to the court means you are burden. Don't come. He should solve that. Now,
24 is there, my lord, I am there.
You assist here in this matter. So you rope in some youngsters also, they will also learn. You are no more a youngster, you have to handle some young he himself will do that. That Robin, that why she is not doing anything? You assist. Give your name. Give your name. And you have to do the maximum work. And he is busy counsel and you have to assist. Give the name, huh? And whoever have lesser experience, you keep the name. The youngsters are waiting. You keep the name, and some senior counsel along with them will appear. Okay. And Tuesday, Thursday, 95 meter. Thursday. Next week. Huh? Tuesday, because Thursday is this Thursday you will do. Can you do it Thursday, day after?
Yes, madam.
What is the offense? Let us see. Convicted. Just see from here. Take it out, madam. Take it out and tell your senior what. Just let us have a overall look about. 307, huh? 10 years.
10 years.
Tuesday I'll take because 10
Hello.
years sentence.
Hello.
Is a heavy matter.
Not I
And in
for reason
beginning-
I will
big-
take the paper book.
beginning remark is he says that direct evidence.
That.
So therefore, you have to prepare in that level.
Okay.
Tuesday,
I don't 24.
24. Yes, 95 meter. You can do it.
But the 95, in fact, this is the second joining of the appellant, my lord. In the year 95, this appellant filed a criminal appeal against challenging the conviction, my lord.
Same conviction.
My lord, same condition. This one report, my lord, in the 95, remitted the matter. That was the collector file has come or not, my lord. Earlier file is
Remitted the matter.
for fresh trial. Since some questions are not cross-examination, some questions are not put to the IO and the other.
When the incident?
Incident taken place on 25/7/94.
Okay. He was convicted
My lord,
by the trial court and he filed an appeal.
appeal.
And that appeal was, the conviction was set aside and remanded back
Remanded
for retrial.
for retrial.
And after retrial again, he was convicted.
Refer the
Therefore, this offences are
20B NDPS Act
20 PN.
and so also 47 of Bihar and Orissa
6
Act.
kg ganja.
6 kg ganja.
Yes.
6 kg ganja found in 2 bags, my lord. First bag containing 5 kg ganja, second bag containing 1 kg ganja, and 4 kg of bhang. So for 47 Bihar and Orissa exercise is concerned. In this case, my lord, all total 4 witnesses. Out of 4 witnesses, PDOL 1 and PDOL 3, they are the seizure witness are independent. They have declared hostile.
There are 4 witnesses.
4 witnesses examined by the
PW1 and
PDOL 3 hostile.
of the same style.
Same style.
I've identified the signature, but
Exactly.
it is blank signature.
And what happened in this case? Though the seizure witness have not supported the fact number seizure, or they have only stated nothing seized in their presence, only they sign in the seizure list in a blank paper. Interesting, the
That you 90% cases you will find this same.
same manner. What happened in this case, my lord? The IO is the excise police officer. Though he seized the ganja in question and bhang and arrested the accused, taken him to the office of the excise police officer and remained there 1 day. That seized ganja has not been remain in self custody. Section 55 of the NDPS Act. Neither the excise police gave information to the local police station or kept the same seized materials in the police station Malkhana. But he himself kept the ganja with him. On the next day, he produced the accused and all the seized materials before the magistrate. GMFC, Jajpur Road.
That is 55 not compliant.
55 not compliant. And with regards to the evidence, though the 2 of the independent witnesses, they have seizure witness, they have not supported the case. But PDOL 2, is the another ASI of excise police. And
Then the entire case rests on PW 2 and 4.
2 and 4. I will read out the evidence PW 2. At page 9, Xerox kar diya.
Yes. You can see from there.
No, it will page. Xerox kar hath nahi. Pen drive rang.
I know the accused.
I know the accused since last 3 to 4 months. I am serving as a ASI of excise at a Jajpur Road since 2 years. On 25/7/94 at about 9:30 am, I had been to Mituani Pond for a patrolling duty along with the excise SI RP bag. RP bag is the pedal 4. While we are so performing patrol duty, we got information that this accused was bringing ganja and bags and bangs was coming. We detained the accused at a Mituani Pond. When we asked him if he desired to search before the gazetted officer or magistrate, but he refused to the search before officer or magistrate, then we called the local witnesses, namely that's not one of the witnesses not supported, and another he has not also supported. The SI
Not over is PW?
PW 1.
Okay. And another. Yes.
And another. The SI excise gives his personal search to the witnesses and search the person of the accused. Here, my lord.
How many accused initially? One.
One. Here, my lord. This witness, PW 2, an official witness, he has stated that no option given to the accused in writing whether he wants to examine search by the magistrate or gazette officer. He only stated that we call over the SI excise give his personal search to the witnesses and search the person of the accused. So the section 50
written this thing was not given.
He stated, but the IO, he has stated I have given the written. For that reason I have contradiction. On search, we found 5 kg ganja in one jerry bag, and in another jerry bag 1 kg of ganja was found. In the third jerry bag, there was 4 kg of bhang. The ganja was shown to the witnesses by
its smell. And also due to my
personal experience, I knew the ganja and bhang. SI prepared the seizure list at the spot. The content were read over and explained to the witnesses and the accused and obtained their signature. All the 3 jerry bags contained ganja and bhang were paper slip with wax. They were sealed. Before ganja and bhang were sealed, 50 grams of ganja and bhang from each packet were drawn as a sample for chemical test. It is very important as because the IO stated that no sample was drawn in this spot. We have produced all the seized materials before the magistrate. In presence of magistrate on the next day, the sample was taken.
Was arrested and forwarded to
the accused arrested and forwarded to the court. Exhibit 2/1 is the seizure list. Exhibit 2/2 is my signature. The accused was signed on the seizure list. Exhibit 2/3 is the signature of the accused. The sample drawn at this spot were sent for chemical test by the SI excise through court. Sample malady reported. Sample drawn at this spot. But in fact, sample drawn at the court that has been sent to the for chemical examination.
Okay.
That is the IO's evidence. MO1 is the jerry bag containing 4 kg bhang. MO1 is the jerry bag containing 4 kg bhang. MO2 is the jerry bag containing 5 kg of ganja. MO3 is the jerry bag containing 1 kg ganja. MOIV is the sample bhang sent for chemical test. MOV is the sample of ganja sent for chemical examination. MOVI is the sample of ganja sent for chemical test. Cross-examination. There are 3 passages which comes to Mituani Pond from the public road. There are many houses near Mituani Pond, but I do not know the owner of the house. Mituani Pond came under the ward number 10 of the Jajpur Road NSC. The SI excise prepared the spot map. At this spot, we were 5 persons of our department. Besides SI excise and myself, myself, 3 more constables also present during the seizure. The constable have not signed on the seizure list. Accused was coming from north to south. We had gone to the
last line of para 5. The sample drawn
at the spot
were not sealed, and the articles were sent to the court in the sealed condition.
sealed condition. The sample drawn in the spot were not sealed.
We brought then section 55 you are talking about. That is compromise.
We brought the OMH scale and weighed 2 kg 500 grams and 50 grams from the nearby pond. The articles were weighed by me at the spot. Those weighing scale and weights were returned after the work was done. Constable Chinmay Kumar Das called the local witnesses. IO has a
What is the recovery then?
My lord?
6 kilo.
6 kilo.
But weighing is 2 kg only.
2 kg
500 gram.
2 kg 500 gram
50 gram.
50 gram. How they weighed that is even if my lord, the case is they have not examined the person from whom they
bought that weighing machine and all.
weighing machine and all. That is not there.
Weight is this much. 6.
How 5 kg my lord? Did not 5 kg. How they
2 kg 500
measure
gram and 50 gram from the nearby pond.
How they measured my lord the 5 kg? It
We
is
brought the weighing.
not possible on their part.
What is it?
2 kg ଆଣିଲେ ଗୋଟେ 500 ଗ୍ରାମ ଗୋଟେ 50 ଗ୍ରାମ ଗୋଟେ ଏଟା 5 କିଲୋର ଓଜନ କେମିତି କରିବେ ସେଟା ରାଇଟଲି lordship matter point.
Neither you are declared hostile nor we examined the public press.
The scale what
The articles were seized. Botkara जो
ବଟକରା ଗୁଡାକ ସେ 2 କିଲୋ ଗୋଟେ 500 ଗ୍ରାମ ଗୋଟେ 50 ଗ୍ରାମ ଗୋଟେ ଆଇ ଗୋଟାଏ 5 କିଲୋ ବାହାରିଛି କେମିତି ସେ ଓଜନ କଲେ ସେଟା 5 କିଲୋ ଆଣିଲେ କେମିତି ଆଉ ଅଜାର ଦେଲେ ତ ସରିଲା କାମ ତ ଟାମ୍ପର ହେଇଗଲା
Tampere hବନି ଜରିଟା କେମିତି ଅଲଗା କରିବେ
ସେଟା ମାଷ୍ଟର ଟାଇପ କରିବା କଥା ନା ଏକ୍ସରସାଇଜ ବାଲା ଏମାନେ ଏକ୍ସରସାଇଜ ବାଲା
in the article and after drawing the sample
balance
ganja
bhang were sealed separately.
I have not gone through the special training so
Identified
all these things are relevant not relevant.
I was not knowing.
Let us come to 4. You recall for further examination. What is this?
Recall is 28 and 95. That is, my lord, after the judgment of this report, my lord. 2 persons recalled for
Okay.
2 and 4.
Okay, this is very important. After recall, what is the
This spot is about 1 kilometer away from Jajpur Road, PS, and court of JMFC Jajpur Road in about 1 km away from the PS. PS, my lord, PS. My contention, they have not kept the ganja, seized ganja and bhang in the police station. But the police station 1 km away from the PS. JMC, this spot is about 1 kilometer away from the Jajpur Road PS. The court of JMC Jajpur Road is about 1 kilometer away from the PS. So, man, in the night they kept the ganja in the excise office. Who debarred them not to taken the accused and the ganja to the police station, which is 1 kilometer away from this. From that, in the has been
No, it is written that day the accused and the articles were detained at our office.
Admitted.
I had also accompanied the accused to the court on the next day. And it is not a fact that the no ganja or bhang was ever seized. It is not a fact that so. This is the recall.
Recall.
This is the recall. Where is the judgment of 95? 95 judgment is there.
Is there?
95 judgment is there. The earliest judgment is 19/195.
No, 19/195.
No, in this appeal.
91.
You challenge which judgment?
22/11/95.
19 judgment. Let us see the operating part. Why it was
same thing, my lord. Same. Only because, my lord, section 50, relying section 54, the court presumption, the court committed in both the judgments. Only relying on the presumption, section 54 of the Base Act. That much.
Okay.
Here, my lord, I can see judgment, my lord.
What is the reasoning by this court?
This can see that has been not cross-examined by the. They have not been cross-examined. The witness has not been cross-examined.
But they were cross-examined.
some question they have perhaps
is-
that
where is the
what is available earlier judgment is also available in the case record, my lord.
Where is that? Argument submitted.
I think that is available in the case record. Earlier judgment of this court, my lord. $10,895 perhaps, my lord, the earlier $10,895.
Do you have the appeal number?
Appeal number, my lord. Verify कर दो।
It's not there, it seems.
लेकिन बोर्ड अच्छी है।
This criminal appeal number 35 or 38?
35.
35 of 1995.
35 of 94.
10,895 ରେ judgment ହେଇଛି। 10,8 earlier appeal 35 or 95. In
This
that
I-
case,
we don't have that order. No?
that is order available with the LCR perhaps.
Sure.
Fine, put it.
ଅଛି ଗୋଟେ ଅଛି LCR ଥିବ ସେ।
LCR, it's not there. Just see, check it here.
ଦେଖିଥିଲେ ଏଇଟା ଅଛି। ଅଛି LCR available ଅଛି।
Just check it up.
ମୁଁ ଦେଖିଦେବି
Can get-
ସେ ଦେଖିଦେବି after break
Just registering phone call appeal. Last order. Can you get? Huh? Let us see. I'll try
order
to.
ଅଛି ଏଥିରେ ମୁଁ ଦେଖିଦେବି ମୁଁ
Huh? No, it's not there.
ଅଛି
Just check it out.
ମାନେ 10 ମାନେ ଅଛି
Huh?
ଏଇଟା ଅଛି
Paperwork ରେ.
ମୁଁ ଏଇଟା ଜେରକ୍ସ କରି ଆଣିଛି ପେଣ୍ଡ୍ରାଇଭ ମତେ ପେଣ୍ଡ୍ରାଇଭ ପଠେଇ
But here
ମୁଁ ଅଫିସିଆଲ ମତେ ପଠେଇଛନ୍ତି ନା ଏଇଟା ହାଇକୋର୍ଟ as per direction by your lordship, my lord, this they given in pen drive, I print out my lord justice A Prasad. Fresh trial by ଯାଇଥିଲା। High Court registry supplied the PDF format to my mobile for that. I have print out this. Delhi ଆଜି ଅଛି ବା ଦେଖ ଗୋଟେ ପୁରା ସ୍ପେଶାଲ ହାଇକୋର୍ଟ ଥିବ ଦେଖିଲି ଫର୍ମାଟ ଟା ଟିକେ ସରି ଏଇଟା ଇଏ ହେଇନି ହାଇକୋର୍ଟ ଲେଖିବ
That is there, man.
page 24.
Page 24, criminal appeal number 35 of 1995. It was
Ranjit Kumar Singh.
1/8/1995, order dated.
195 order that challenge that is.
See, the court said that the witnesses were examined, but sufficient opportunity is not
Not given
given
for
to
cross-examination.
the-
For that in their recall for cross-examination. Both the official witnesses.
Because
This will come
in
just-
this case, supplementary PR was filed and opportunity of cross-examination was not given
And
for that.
then PW2 and 4 was again recalled.
Recall.
Yes.
And on the recall,
They were
That is
cross-examined,
filed.
thereafter again judgment was given.
in the it's a PW2 I have read it.
Yes.
PW2 at least after cross-examination this much they could get that the samples and the articles were kept
For a
in
while.
their own custody for about 1 day.
One
Yes.
day.
But they did,
So
it was
55
it was detected at 9:30 a.m.
uh,
If on that day they would have produced the seized ganja before the learned magistrate, nothing would have happened.
Not on the next day.
so that there you concentrate. Now we will see PW4. I'll just
My lord. 4, my lord.
Yes.
The IO. On 25/7/94, I was serving as a SI of excise at Jajpur Road. That day, at about 9:30 am, I, along with my staff, doing patrol duty near the Pitwani tank area at Jajpur Road. While so patrolling, we got information that the accused was carrying ganja and a bhang near Mitwan tank on the road. Then we went and detained this accused, called the witnesses. Then I asked the accused, he desires to be searched before any gazetted officer or magistrate, and he refused. But he has not, the Pidol 3 has not stated so, my lord. Whether they have given option. Only he has stated the IO, excise IO search.
Yes.
I conveyed this fact to the accused writing. At that time, the accused was having 3 bags with him, then opened the bag in presence of witnesses and found 2 bags.
But he has given in writing, but is it exhibited?
Exhibited judgment.
Doesn't say that. One bag containing 5 kg ganja and the 2 bag containing 1 kg.
1 kg.
And the third bag was containing 4 kg bhang.
Oral report, copy of the preliminary statement of the. No, you didn't.
It is a sample and
That has not been
He
validated.
used to write that in PR.
PR କଲେ, ସେଟା ହବନି।
ଲେଖି ଦିଅନ୍ତି ଯେ option ଦେଲୁ accused.
ସେଟା ହବନି।
written, you have to give in writing.
Writing.
There is a format to that effect.
Format to that.
All excise cases, they used to write in the that side of the preliminary PR that we have given an option to accuse.
That kind. In
You
NDPS
have
Act,
to give in writing,
Yes,
and read and explain.
Just that.
he's doing so many cases in NDPS and vigilance cases.
Then see, I am going to pronounce one judgment. They are the same thing. Even if there are 2 accused, separately you have to give in writing.
Even in
If
writing.
jointly you give, then also it is not compliance of
Not compliance.
50.
Right.
Yes, para 2.
Para 2.
I extracted that part. Just see,
I extract 50 grams from each bag as sample.
Extracting the
After
sample.
extracting the sample, I sealed the seized bags with the paper seal containing the signature of witnesses. I also sealed the sample packets containing the signature of the accused and witness. But Pidol 2 stated is that they have the samples are not seized, sealed.
That is there. Exhibit 2/1.
Sealed.
It is there.
Exhibit 2/1.
Koda
That
kara?
50 option. Whether you want.
ଓ ଯୋଉ ସେ ଇଏରେ କଲି ବୋଲି ତା ପଛପଟେ
ନାଇଁ ସେ ଇଏରେ ଲେଖିଛନ୍ତି exhibit C/1.
ସିବିଆଇ
ତଲାସି ପୂର୍ବରୁ ଆସାମୀ
Preliminary-
ନିକଟସ୍ଥ ଗେଜେଟେଡ୍ ଅଫିସର କିମ୍ବା ମାଜିଷ୍ଟ୍ରେଟଙ୍କ ସାମ୍ନାରେ ତଲାସି ଦେବେ କିନ୍ତୁ ସେ ଅନିଚ୍ଛା ପ୍ରକାଶ କଲେ ଏବଂ ଆସାମୀ ନିଜେ ଏକ କାଗଜରେ ଲେଖିଦେଲେ ଯେ ମୁଁ ଆପଣଙ୍କ ଉପସ୍ଥିତିରେ ତଲାସି ହେବି।
ସେ କାଜ
Where is
ନାହିଁ
that କାଗଜ?
ସେ କାଜ ନାହିଁ that had not been executed.
ସେଇ କାଗଜ କୁଆଡ଼େ ଗଲା?
Then I intimated the accused, writing the ground of arrest. Then I prepared the seizure list at the spot in presence of witnesses and the accused. Then the content of the seizure list were read over to the witnesses and the accused. Thereafter, admitting the content of the to be true, they sign it. Then I served the copy of the seizure list to the accused and obtained his signature. Then I recorded the statement of the witnesses and the accused at the spot. Then I produced the accused seizure articles, seizure list, documents before the magistrate at Jajpur Road. He has not stated when he produced before the documents.
No, but
But-
see,
but
para 2 at the top.
Alright.
I extracted 50 gram of from each bag
Alright.
as sample.
Sample.
And after extracting and the sample, I sealed it. Okay?
But
now
the-
come to para 4.
4.
Top.
Again,
I draw 50 gram of sample from the seized bag.
Seized bag in presence of the magistrate. On the next day, when they produce the content.
Then
The question does not arise.
2 samples were drawn.
But the sample which was
And the samples were sent.
which was drawn before the magistrate, that has been sent, my lord.
That's what I want. Which was sent.
That is the procedure.
That's the procedure. But which was sent.
Which was magistrate. But there is no, my lord, if the sample drawn in presence of the excise at the spot, my lord, that that has to be sent to the concerned magistrate. Here the case that has not been sent to the concerned magistrate. Where that sample is gone, that is no question, my lord.
That's what I'm just
My lord.
looking at this evidence.
Right.
Whether the sample drawn from the spot was placed before the magistrate.
No, that is not there.
Samples
That
are sent to-
Pidol 2 has not stated so, my lord.
But he says
That is open.
para 4 just read.
My lord.
Para 4 just read.
Again, I drew 50 grams of sample from the seized bags in presence of the magistrate on this next day. Then the
Then the
sample
plural, samples were sent.
There are since there are 3 bags, my lord, for there are 3 samples, my lord. Samples were sent to the chemical examiner FSL Rasuga through this MFC Jajpur Road. I also deposited the articles in the court Malkhana under Malkhana Mal Chalan. Today, I am filing the copy of the Mal Chalan Exhibit 4 is the copy of the forwarding memo of Magistrate Jajpur Road for sending the samples for chemical examination test. When he was examining chiefs, he had produced the same. Earlier, he had not, when submitted the final PR, he has not submitted the documents. My lord, he has kept the Ganjani
Yes.
court Malkhana.
I prepared the seizure
I have
list.
prepared the seizure list, divided exhibit 2/1 and 2/5 is my signature. Within 48 hours, I sent the preliminary report and the copy of seizure list to the inspector of excise, Jajpur town, from the date of seizure, exhibit 5. The copy of the preliminary report sent by me to the inspector excise. I have record the statement of Pidol 1 to 3, exhibit 6 is the statement Sankar Naik, Pidol 2, exhibit 6/1 is the signature of Sankar Naik, who was a sign in my presence. Exhibit 7 is the statement of Pidol 1 recorded by me. Exhibit 7/1 is the signature of Pidol 1, sign in my presence. Exhibit 2/3 is the statement of Pidol 3 recorded by me. Exhibit 8 is the spot map prepared by me. I have examined Pidol 3. It is a fact that Pidol 3 has stated to me that being called by me, he became a witness. In his presence, I recovered 3 bags from the possession of the accused.
Yes, and thereafter he
Madam.
next come to a cross examination.
I have
filed
the final PR on 21/11/94 before the JMFC Jajpur Road. On the date of submitting preliminary PR, I have not filed the 1/1 statement of the witnesses, but I have not mentioned in the forwarding report regarding the existence of 1/1 statement, but I have mentioned these facts in the preliminary report itself. Even if he has stated in his chiefs that he has recorded 1/1 statement at this spot, my lord. But while forwarding the documents, he should have sent the 1/1. So it is, my lord, by subsequent stage, he has recorded, I think, my lord, the 1/1 statement. I mentioned the facts in the preliminary report itself. It is not a fact that I have not mentioned in the preliminary report that 1/1 statement are in existence. I have prepared the final PR on 21/11/94. It is not a fact that mentioned in the statement Sankar Naik was corrected from 27.
When the 1/61 statements were filed in the court?
Madam,
when 1/61 statement?
When he submitted the
final
preliminary PR.
No, he says the along with the preliminary PR, he is not.
When it's so final, sorry, my lord. Final PR on 21/11/94. He has submitted on that day, my lord. Even, my lord, he stated that he has recorded on at the spot. But while forwarding the accused and seizure, he should have sent the along with the PR to the court, my lord. He has not sent, my lord. That is lacuna, my lord. Important fact, my lord, the further concession at page, my lord, as per in portions order, this one court criminal appeal, my lord, in the page, my lord, 7, my lord. Continuing page 7. That is the material, my lord. Subsequently, my lord, he has been cross-examined, been recalled after judgment of this court.
Let us see that.
That page 7.
Yes.
Now I am serving as a SI excise Baleshwar. I get the information while doing petrol duty. We used to conduct petrol duty, and after return we enter the fact in the station diary. We apprehended this accused immediately after receiving the information. I recorded the statement of the witnesses and the accused at the spot. I gave option to the accused if he desires to be searched before the magistrate, but he refused to be searched before him. So I also obtained the fact from his writing. I have not maintained a diary. Everything is mentioned in the PR. On the backside of the signature list, seizure list, the accused has signed in English, and below it is mentioned in Oriya, receiving a copy, and below it his signature is attested. It is not a fact that no copy of the seizure list supplied to the accused, and it was a blank paper. The offer I made to the accused regarding his search before a magistrate in mention in this statement of the accused recorded by me. The signature of the accused is taken immediately after his statement without any gap. It is not a fact that I obtained the signature of the accused in a blank paper by giving a cross mark, and thereafter the blank paper was filled up. It is not a fact that the cover, the blank. The fact that it is not a fact that cover the blank paper, certificate and a seal was given by its side. It is not a fact that no option was given to the accused to be searched before the gazetted officer as required under section 50 of the NDPS Act. It is not a fact that in the document where the ground of arrest was intimated to the accused signature was obtained after leaving a space of about 6 inches from the writing portion. It is not a fact that I had given a cross mark whether the accused has signed, where the accused has signed. Since I was busy for revenue collection and investigation, I could not send these documents along with the preliminary PR. I did not send the
Yes, I read.
articles.
I read the full. Now, what is your take? What is the final?
Final, my lord, the independent witnesses have not supported the case, and though the
First one is
independent witnesses
PW 1 and 3. PW 1 and
Three.
3
not supported the
independent
Non-compliance of
witness
55,
not supported.
my lord, and non-compliance of section 50 and 55
Section 50,
and 55,
50 not 50 and section 55. 55 not complete.
my lord.
Not complete.
And there is a contradiction evidence given by the PW. Two and
Contradictions are very minor.
My
That
lord.
is not important. Twice
My lord.
the trial court has
I am
convicted you.
giving one judgment of the lordship, recent judgment published in
Twice the
This
trial court has convicted you.
And my lord, another thing, my lord, that has been kept in the excise office for one day.
That is 55.
55.
That is 55.
Exactly.
What is this?
Your my lord's judgment, my lord. Exactly same case. Here, my lord, one independent which has not supported, and PW 4 excise has supported. Consider the fact.
Yes.
Exact decision.
Which one? Which paragraph?
Abu Padar said. 8, 9, 10, 11 है सब डाला.
8,
9, 10, 11. Here, my lord, the two seizure witnesses declare hostile.
Cross-examination, he has stated that these articles as well as seizure list were produced on 25/7/94. Incorrect.
Incorrect.
It starts from
26.
26/7/1994. So admittedly, one day after the seized articles were produced before the magistrate. That is on record, my lord.
no, it was
Well, state class is very fair, my lord.
because he has been doing.
My lord,
See,
experience, having
this is
experience. I
the-
know him.
This is the role of a state
My
counsel.
lord. He had to
He
assist
is
the
not
court, my lord.
defending a state. He is assisting the court.
I am also doing same thing while in
That
that side,
should
my
be the
lord.
spirit, not the
lord.
wrong thing you can keep on, harping.
lord.
That's not
Exactly.
fair way
He is
of
fa-
thinking.
For that reason, my lord, he is very fair, my lord, to the
When it was seized, according to you,
25/7/94.
seized on
25/7/1994.
794 and
Produced before the magistrate on 26/7/1994.
on the next day.
26/7
1994.
and it remained in the custody of the IO.
But in cross-exams, para 21.
Samples and the
This is bomb quantity.
quantity.
Cross-exam is para 21. Towards last 7 line. They have stated that it was produced before the JMFC justice.
On the same day.
25/7/9.
That is wrong. But the order sheet is started from 26/7/94.
10 lines from bottom.
VW
Produced the accused, seized the list, seized the articles before the JMFC judge wrote on 25/7/1990.
That is not correct, but
लिख दियो खाली पॉइंट्स लिख दियो I may forget it right later. Mr. Ragada has pointed out three apart from pointing out the inherent contradictions in the statement of the prosecution witnesses. He has primarily pointed out three aspects of the matter. One is number 1, 2, 3 Corgo. 1 Corgo, PW 1 and 3 are the independent witnesses. Those who are not supporting the prosecution case. First. Second is Section 50 of DPS Act has not been complied. Why Section 50 according to you is not complied? Because
nothing has been given in writing, my lord.
Because it is eminent from the record that though the IO has stated that in writing he has sought the opinion of the accused regarding the search and seizure. However, the notice alleged to have been given to the accused has not been executed. Has not been executed. Secondly, section regarding third point. Section 51, non-compliance of Section 55. The IO on the further recall, IO PW Court on further recall, in the cross-examination, he has stated that the seizure for the ganja and the bhang was effected on 25/7/1994, and the sample was drawn on that day. And it was produced on 25/7/1994. However, the proceeding of the trial court indicates that in fact the sample and the contrabands were produced before the magistrate on 26/7/1994. Therefore, the sample and the contraband remain in the custody of PW4 for our day, and hence this is against second compliance of 55.
Another thing, your lordship pointed out that thing, my lord, the scale and the scale, my lord, which from whom they have brought that has his name not mentioned in the.
That's very material.
काठ वाले की तक कौन है पर दुकान वाले का नहीं सीधा.
But the fact is they've got it.
इतना जिबारी कैसे पड़े?
200 what color 50 and 500 and
2 kg
50
550 gram
and 6 kilos.
my lord.
So they might have used multiple time that vodka for and but I don't know whether they separated and see there is the problem.
Should I say
6 kilo, 1 4 kilo and have they separated it?
nah, no.
found quantity in an old newspaper, thereafter.
Then they remove from the bag.
Yes.
ରିମୁଭ୍ ସରିଲା ତ କମ ଆଉ ସିଲ୍ କଣ ରହିଲା ମାଷ୍ଟର
Then?
ପ୍ରଡ୍ୟୁସ୍ କରିବା ପାଇଁ କେସ୍ ଗଲା ଟେମ୍ପର ହେଇଗଲା ଟେମ୍ପର ହେଇଗଲା
The entire bag has to be done. Thereafter, you have to draw the sample. Not that you remove from the bag and put it somewhere, then you wait and put it again, and then sample.
କରିପାରିବି
This is not the way.
କରିପାରିବି ସେମିତି
Then you
That time
compromise
ହେଇଗଲା।
the
Years back, conducted a case, 14 tons of ganja were seized, one truck.
and then suppose they were in the bags, then accordingly they have to do. Not that the everything will be removed from the bag and put thereafter you doing it. You can't do that. Can't do that. Weighing up the contraband seized from the accused is also compromised. Let upon the stage. There are evidence for this thing. That what recording. Okay. Okay. Thank you. Thank you. Thank you. Yes.
Item 56.
No, he already.
Item 17, Lordship.
Which one?
Item 17, Lordship. I'm filing the written notes, Lordship. I've already served a copy on the
17. 95.
Which one,
Proof. Love.
6 months, Lordship.
6 months.
Lordship, in this matter, no caste certificate has been furnished. SC/ST Act is there. Lordship.
Item 15 was there.
15 also. I'll take it up.
Sir, 15 next week,
Why?
Thursday.
Today you do it. At 2 o'clock, what is the problem?
2 o'clock, lower court.
Trial court.
Trial. Sorry.
He's correct. No court is lower.
Yes, trial.
That's why TCR.
Court is the court.
With
That's why
brother.
now it is a PCR.
Learning from
Naturally.
it.
Earlier it was LCR, now TCR. Trial court record.
Learning from brother.
That's very important. So you are not available after lunch. Okay.
I was there
Thursday.
since morning. I was
Okay, Thursday.
first.
Have you prepared
Yes,
written note?
everything.
Written note.
Judgment.
Thursday.
Item 15.
15, huh?
15.
Who year, no? 15.
95.
95. Thursday. Thursday.
Last occasion also it was, hence I reminded. My lord.
Oh, Thursday. You should have told in the morning. Record of matter I have taken. I could have picked up your matter.
I was waiting because 15
Wait.
serial number.
Whoever
was
is there.
So low serial number, so I.
Okay, solve.
And can suggest if today somebody from the appellate side say that we are ready there so that it can facilitate any other thing.
No, that's what I told him, that he please ask the lawyer, whoever is ready. Otherwise, you people will be free, na?
Hence I was asking.
Uh-huh.
Hence I was asking because early morning also.
But Tuesday you come and mention in the morning only.
Thursday.
Thursday. So that we will finish.
Yes.
That. Okay.
Yes.
Now you are free.
Obliged.
Yes, what happened?
Lordship,
Yes.
there are 5 grounds, Lordship.
5
One-
rounds.
Yes, Lordship. One is delay in lodging of FIR.
How much delay?
Lordship, more than 24 hours. Because as per the FIR, incident took place on 1st February. But the FIR was
Now,
lodged.
who is the victim? Tell first. Let us see the victim. We'll read this history.
PW1 is the victim,
Let us
Venudhar
read,
Bag.
read the statement of PW1, then we get a clear idea about the case. Yes.
Venudhar Bag, Lordship,
Yes,
that is
Victim, huh?
Page 24.
24, Lordship.
Read it.
I know the accused Subha Vastia village, Patuapalli. He is the Sarpanch of Patuapalli GP. When I
How many accused? Only one accused.
one accused, Lordship. Now the accused is 74 years, Lordship. Because of the political rivalry, he has been implicated.
The
When I-
occurrence took place last year on Tuesday at about 5 p.m. At that time, I was coming from the tank towards the Basti. The accused came from opposite direction and met
Met me near
near
the
the
club of our
club of
village.
our village.
The accused all of
a
a sudden
Accused
got
all
hold
of a sudden cut hold of
my shirt
collar,
and abused
shirt and
attributing as
abused,
Gondo by caste
attributing
and gave me pushes
attributing what is attributing
as Gondo.
Gondo. by cast
by cast.
and gave me
Gave me
pushes.
pushes. On account
And
of
on account
such
of
pushing, I
pushing,
fell down on the ground. I became senseless.
Became senseless.
Bonomali Podho,
Bonamali,
Podho.
and
Aibar
so-and-so
Kshatriya.
gave me the first aid and supported sprinkle the water, so-and-so, so-and-so. Bonamali is examined?
Yes, Your Lordship.
PW?
3.
PW 3. And next person, Oibol.
Koibalya. PW 4.
PW 4. This is the allegation.
Yes, Your Lordship.
Thereafter, I regained sense. From the spot, I came from the house, and the following day, I came to the PS. And the following day, he came to the PS and submitted the report, and which was
Scribed by one Sahadab Mahakut. But the scribe has not been examined.
Not examined. Okay, not examined.
He wrote on my direction.
He himself says that one day thereafter he has lost the FIR.
Yes, Lordship.
And he wrote on my dictation and so and so. Okay.
The contents, read over the contents to me and admitting the same.
Village is also reaching here and
I submitted the written report before the OIC of Louisiana Police Station.
Report was submission. There was no road inside so occurrence to place. There is how the house of governor is so the time of occurrence Koivalio Bonamali and so and many other were present. And the club so come to IO.
Lordship PW 5, Lordship.
PW
5.
Let us come to IO. PW 5.
Page 33.
Take it.
I was the JSI Louisiana PS. On that day, PS case number 9 of 94 having been registered by the OIC. I was directed to take up the investigation. During course of investigation, I examined the complainant at the PS. I visited the spot and examined other witnesses.
I visited the spot and
I prepared the spot map. Exhibit 2 is the spot map.
And
on 24/2/24, I arrested the accused and forwarded him in custody to the court. On the same day, after completion of investigation, I submitted the charge sheet under section 341, 294, 506, section 3 of SC/ST Act. I cannot say if the complainant is supporter of Janata Dal. In my forwarding letter, when I forwarded the accused to custody, I have mentioned that the complainant was a man of Janata Dal. It is a fact there was political rivalry between the parties. On 2/2/1994, I visited the spot. On 5/2/94 and 24/2/94, I had also visited the spot in connection with this case. On 4/2/94, I examined the witness Koibala Kshatriya and Bonamali Port at the PS. I have not.
where is the certificate? Nothing is there.
No,
In absence of certificate.
in the judgment also.
I have given some.
Yes, Lordship. I have cited.
It has to be established. And the victim also doesn't say anything, except saying that I am Gondo.
Lordship, may kindly have a glance at page 15. Lordship, may kindly have a glance. List of exhibits. Page 15.
Gives the 19.
No, IO has not said.
Yes, sir.
I've seen that he or he has produced any document. And
Even
it is not only you, the prosecution has to prove that he belongs to, the victim belongs to
the particular
ST part. It is also they have to prove that the accused belongs to SC/ST. That's the judgment. Where is that judgment? You have relied upon that judgment. One of my judgment, I have said that it is because the Act says that it has to be established that you don't belong.
Pradeep Sahu versus State. Lordship had delivered this judgment.
Where is that Pradeep Sahu?
I have annexed Lordship.
Yes.
CRA 94 of 1995.
Yes. Which paragraph?
Lordship, para 8.
One of the state witness
Para 8 and 9.
8 and 9.
Yes, Lordship.
Yes, read it.
The learned counsel for the appellant has taken me to the evidence on record and pointed out the glaring contradiction. Apart from that, the learned counsel has submitted, even if the prosecution version of the witnesses are accepted, no specific case under section 3(1)(11) of the SCST and PO Act is made out because there was no intention attributed by the victim on the part of the appellant to commit the crime with an intention that it is being done on the ground of her caste. He has relied upon the judgment of Dasarath Sahu versus State of Chhattisgarh.
Yes.
He further submitted the present case. The prosecution has failed to bring on record the evidence establishing the caste of the victim.
Caste of the victim, yes.
He submitted that neither sufficient oral evidence came on record nor any iota of evidence in the name of documentary evidence borne on record to suggest that the victim belonged to either SC or ST.
Please rely upon the judgment.
Lordship, I have annexed that judgment also,
Yes.
Dasarathi Sahu. After both the judgment, Khogeshwar Kumar and Dasarathi Sahu. Both have been
reproduced for 5. The main condition of the Vedi is that even if evidence of all the witnesses is taken as between no opponents made out and is upon taking of
Lakshman, kindly have a glance at the second judgment, Khogeshwar Kumar versus State of Odisha. Para 5, the relevant para.
With an intention that he being this is important. Yes.
Lordship,
Yes.
that
Next.
is
Khogeshwar, that judgment is there.
para 5, in Khogeshwar, para 5.
Para 5, yes, I agree. Para 5, na?
Yes, Lordship.
Para 5, yes.
And Dasarathi Sahu, Lordship.
Para 5. Yes, para 5. Yes. Dasarathi
Sahu, Lordship.
para
Para
which para?
9, 10. 10, Lordship. In the said judgment, this court dealt with a case involving occurrence under section.
This is very important. With an intention.
Yes,
With an intention that it was being done on the ground of his cause. This is very important.
Thing has to be proved. Contention thing has to be proved.
There is nothing.
Allegation is not proved. Suppose committed fraud has to be proved.
There is nothing.
Transfer has to be proved. Suppose if the allegation that he belongs to that class.
Because he belongs to SC, therefore this act is there.
Trial court would have brought on record that notification, residential notification, that is something otherwise. Manda is that class.
Nothing is there.
If that would have something.
Then the story would have been different. But see, the IO has not made an attempt also.
No, Lord.
Generally from Tahsildar, some certificate, some documentary evidence.
Lordship, and PW2 is also an interested witness because she happens to be the wife of the injured person. PW.
That why should you go to that?
Yes,
Main ingredient
Main
is
is
not
caste certificate.
caste certificate. Okay, good. Okay. Yes, after lunch, who is ready to do the matter? Just like ask. You're ready with any matter?
118 is ready.
Huh?
Note of submission is already completed.
18. Then we'll start at 2:15.
Your Lordship, item 47, Your Lordship. Can it be taken on some other day?
My learned senior.
This is on weekly list, no problem. You get ready and come and argue. Okay. Yes.
87. I have no instruction.
87. Let us see 87. No instruction. No instruction means you don't want to appear.
We will take the instruction and then we'll appear.
You take instruction, it is there in the list. You take instruction. Take instruction. What instruction? Paperwork, everything is ready. You argue. He will give you instruction that you argue only.
The petitioner will take the
Because these are appeals. You have to argue on the basis of the records. What instruction you will take? Read the paper and argue. Material instruction. That's important. You get it. It's there in the list. Then under pressure you get the right instruction.
Item 56. Item 56. Fine. 500 rupees per month.
56.
427.
Let's see 56. Who is appearing?
That's the record on 56.
Gopal Samanti. Let's see. What is the sentence? Considering the evidence on record and circumstances, the offence committed, if any, considered opinion, the fine of 500 rupees each in default to 323. As a 500, only 500 rupees fine. In item 56, only 500 rupees fine on each and under 323. There is nothing. Why we are waiting for this matter to be heard? And this matter is pending in 2008. What to do? Nobody is coming.
If somebody will argue that, then I will not also.
Sir, you assist it. After lunch you will take it.
56.
56. Just 56. Just see. 323 convicted. 500 rupees fine. And this appeal is pending since the 2008.
Paper book.
What paper? No paper book system. Here you just read it. You just read it and I'll appoint you amicus curiae and finish it up right now. How many appellants are there? Only one appellant. One appellant. You read, see the injured statement and doctor statement. That's all. In 323, what will you read?
800 means that is also insignificant right now.
Complete insignificant.
And the 500.
So for 500, if he has come the appeal, you see what kind of fee he might have given to the lawyer.
Only because there is a case to satisfy the.
So therefore, see if it is a case of acquittal, we will acquit it, finish it up. 500 rupees why only. Just check it up, huh? Just they can assist you also. Do one thing, you take out the printout of the. Do you have the evidence? Just see 56. Chevro.
56.
देखो वो चीज प्रिंट आउट कर लीजिए
Paper not yet prepared.
No TCR printout is there
Print out card.
take out the printout and give him. I'll read from here, he will read it and we'll finish up. I'll just now he'll give. Take out the printout of witnesses. How many witnesses? Just 9 witnesses are there. Only witness deposition will give. Take out printout.
My lord, appellant died or not, we don't know. 87.
87. Just see what is he saying. What is the age of the appellant? He was 51 in the year 2010.
51.
It's on like 1 minute. Final form the queue. Let us see the charge sheet. What is this? Thing. What is the name of the accused?
Kirtan.
Kirtan. Kirtan. Rajendra Singh A2. Right?
51. These are those.
66. 65. 66.
Where is the judgment? Promoting another and implicating individual persons custody.
DWC against the builder is not against
Conditions that people persons
judgment को भी है whatever.
Just see, 87 is something different. It's
No
not
judgment, no judge.
he was not an accused.
And judgment copy is not uploaded there. Voice with us.
He was not even an accused. Why? He was convicted of what? Where is the judgment?
Judgment copy is not available in the uploaded document or our file also.
Builder absent.
See the warrant.
No, it is something else. It is he is asking something else. Just check it up. What is he saying?
Annexed one, that is the order.
In the index also, the copy of the order sheet has only been included. Order sheet against the
Warrant. Against the warrant has come up. And the biller Kirtan Naik is the biller. Is absent on repeated call. Repetition from time.
That he has referred back.
So that's what I then
Order dated 2008. The biller Kirtan is absent on repeated call. Which
when he is seeking setting aside of the conviction.
he can.
Only that.
No, please see the prayer.
Prayer Millard.
Lordships graciously pleased to enough to admit the criminal appeal and call for LCR, and after hearing the parties may kindly set aside the conviction and sentence.
That is the
Dated so and so past.
That cannot be.
9. What is the order of 28?
9, huh?
28 के बेलर कितना ना कि ऑप्शन दिया ये माने फॉर्मेटेड थी ला सीधे कॉपी पेस्ट करी करते
Bail Kirtana is absent and repeated calls.
The biller was filed it appeal to pass the sentence.
Allowed the last chance to file Stokas. 10,000 rupees for 10,000 rupees. With special request of advocate. Take the time. Who will dispose it up? What will you do with it?
It's not a maintainable.
Huh? Dismiss it, khatam karo.
Because they are very.
The warrant was issued, but in the
30,000.
meantime.
Bail amount as a penalty, hence penalty of rupees 30,000 only is imposed against the bailer Karthik Naik, son of so and so so and so. The penalty of 30,000 rupees has been imposed on him.
Yes.
That's all.
But he come up and appeal that.
Yes. Related the condition.
Because he was the surety. Then why the court will interfere in the appeal?
No.
Or his part, the accused is
If eventually if they will be acquitted and all, he can move application before the.
And he has filed a case against set aside the order of the conviction.
That's what I was.
The accused is other.
Penalty of 30,000 rupees. In default to undergo civil imprisonment for 6 months. Just see the scope and tell me so that we will dispose it up. This we'll take it up at 2 o'clock. Scope of under which provision this type of order has to be. I think this is 340. No, 344 or something. CRPC. Just check it up. 344 or no, 430 actually. 430 or 344 or something. Just see CRPC. Take it up. Mid sentence. 436 onwards, just see. .436 onwards, just check it up. Just check it up. I'll also check it out. How lunch will do. There is some provision.
My lords, item 7, I appear for the opposite party.
May I please, your lordship? My lord, in this case, my lord, the present petitioner is a naval officer, central government employee, and in serving as the Indian Navy, my lord, and in compliance with the order of the Hon'Ble Court, my lord, he is physically present, my lord, and submitting.
Was there any direction?
My lord, in the order dated 16/12/2025, passed in IA 3860/2025, my lord.
There is no direction for personal appearance.
No, my lord, that is not direction, but so far is compliance of the order of court, my lord. The petitioner want to speak before this one. If lordship may permit him.
Then what is this case is about?
My lord, case, my lord, the
What are you seeking here?
Seeking, my lord, for modification of a lordship order. Let's say the lordship may the direction in earlier the variation petition which has filed since 7/4/2025. That is sub judice in a final position. Till that, my lord, the everything, my lord, the present opposite party having landed property and also
Hey, what is this criminal MC? What is this?
CRLMC, my lord.
What is that?
4692, my lord.
Application may kindly be allowed to directing lieutenant JMFC to keeping the criminal.
My lord, I'm submitting, my lord.
In advance, making variation of application, yes.
In 4692, my lord. My lord, earlier, my lord, the domestic violence case, the order was passed, expiry order. Subsequently, my lord, this honorable court, my lord, set aside the order and direction only two condition, my lord. The petitioner is opposite party in the DV case, my lord, direction to house rent 10,000 and other medical exemptions and the household articles 10,000, my lord. That is two order, my lord. And in this case, my lords have passed the order. You can file a variation petition before the Law and Trial Court. Then he shall consider the same and accordingly dispose of. My lord, subsequently, my lord, as per direction of the National Court, we have filed the variation petition. Prior to that, my lord, the DV case which has passed in the earlier, which has expiry order, that the opposite party wife has filed the execution case before the Law and JMFC 3 court, my lord, which is under the variation petition, my lord, which is pending before the Law and JMFC LR court, my lord. That is two different court, my lord. The as per direction of the Hon'Ble court, my lord, the domestic violence case is pending before the Law and JMFC LR court. But the execution case, my lord, in compliance to the order of the earlier order passed, which was set aside by the Honorable and fresh adjudication can be done by this Honorable Court order. But this order, my lord, this case is execution case, executing the order of the earlier order, which has expiry order. That execution case is pending before the Law and JMFC 3. Accordingly, also the JMFC 3 also aware about the order of the JMFC LR code, though the case is in LR court, my lord, in pursuance to the direction of the Hon'Ble court, my lord, the LR court has directed both the parties to file an assess liability and also 3 years bank statements and also the income tax return, my lord. Both the parties are directed. That is in the final adjudication. Lordship, have a glance. In CRLMC, my lord, that everything, my lord, mentioned. And even if the hour about the same, the London JMFC 3 have passed on.
Which was the final order passed by the JMFC in the DB proceeding? Which is the final?
My lord, DB proceeding, my lord.
Which was the final?
My lord, lordship, I have everything, my lord. The lordship, I have glanced in CRLMC and page 21, lordship.
Which was the final order, you tell me, against which the earlier CRLMC was filed?
My lord, this page 21, my lord. This is the order passed by the respondents are hereby restrained for committing and inflicting any kind of domestic violence.
21 you are reading.
21, my lord, in CRLMC 4692, my lord.
That I know. I have given liberty to you to go and file a variation application.
Variation application.
What is the principal order you show me?
My lord,
why are you going here and there?
My lord, the challenging, my lord.
You give me the order dated 12/7/24.
12/7/24, my lord. My lord.
12/7/24. Where is that order? Where is that order?
My lord, 12/7/24, my lord. My lord, 27/11, my lord.
I am asking the order dated 12/7/24 passed by JMFC in the application under section 25, read to section 28 of DV Act.
This is the order.
Where is that order? Page number?
My lords have quoted this order, my lord. This, my lord, 21 lordship have glance. I am submitting, my lord. My lords have quoted in the order, in the earlier order.
That is para 3, 4, 5, and 6. I have quoted.
My lord.
Where is the full order, full text of the order?
Text order, my lord. Earlier, my lord, this order has been quoted, my lord, filed. But the relevant portion, my lord, my lords have already reflected in the order sheet, my lord. This is the, my lord, order. First one, my lord, the respondents are hereby restrained for committing and inflicting any kind of domestic violence upon the aggrieved person. It is henceforth the respondent number 1 is directed to pay rupees 10,000 to the petitioner toward house rent for separate accommodation.
Where
with
are you
effect
reading?
from- My lord,
Where you are reading?
my lord, page 21, my lord, in CRLMC 4692, my lord,
Yes.
main petition, my lord.
10,000 rupees towards the.
My lord, 10,000 rupees to the petitioner, my lord, got it, my lord. My lord, towards to house rent for separate accommodation with effect from the date of its order. Third portion, the respondent one is also directed to pay 20,000 rupees for other household expenses, including medical expenses, the petitioner per month with effect from the date of application. And fourth one, the area dues from the date of application in 31st/8/2023 towards the household expenses and medical expenses should be paid within 3 months from the date of this order. The monthly dues for September 2023 should be paid by 29/2023, and the subsequent monthly dues should be paid within 10 of each subsiding month. The respondent one is further directed to pay sum rupees 10 lakhs to the aggrieved petitioner within 3 months from the date of this order towards compensation. The respondent one is further directed to return all the Sridhana properties of the petitioner which are in his possession. The aggrieved person is at liberty to take necessary steps as per law in case of violation of the order by the respondent. My lord, this is the order passed by
I
the.
have said that the direction number 2 and 3 you will keep maintaining,
My-
and section 12 will be decided afresh. That's
Yes, my
what I
lord.
said.
Lordship, I have glanced the page para 9 of Lordship order, my lord.
Okay, I read it.
But it is open to the petitioner to move.
Then you will move an application for variation
My lord.
by maintaining direction number 2 and 3.
My lord. My lord, so far is
Then you move in a variation application,
variation application,
which is going on.
which is, my lord, final stage, my lord, there is direction of both the
You show
parties.
me that you are complying with the direction number 2 and 3.
My lord, 2 and 3, my lord, though, my lord, the present petition opposite party, my lord, having, I have given, my lord, in the evidence affidavit, my lord, he has, my lord, she has landed property and in Sohinagar, my lord.
All
and-
these things I am not deciding. I am only deciding that you, now in this petition, you are seeking one thing, that till the variation application is decided, execution petition should be stayed. That's what you are saying.
My lord, no, my lord, my lord, my order of the variation petition, my lord, the file, as accordingly variation petition is pending before the JMFC LR.
I know, but the execution is going on. That's what you are saying.
Execution in going on prior to my, which are set aside by the Honorable Court, my lord, the previous order. This is the, my lord, fresh.
But what about direction number 2 and 3 that I have not set aside?
No, my lord, as per direction, in this regard, my lords have suggested to file the variation petition. Though the, my lord.
But till the application is decided, till then you have to keep on paying. That is what my order is.
My lord.
You can't have both. Till the application is decided, you have to comply direction number 2 and 3. Move application, and if court varies that order, that is a different story. But till it is varied, you have to comply.
My
That's the
lord,
order. Simple, pure and simple English.
and my lord, subsequently, my lord.
No.
My,
Parite, just read. Parite of my order.
my lord,
I am inclined to allow the application of the petitioner, setting aside the ex parte order,
my lord.
only on the ground that the series of directions made by the court below,
petition.
without affording opportunity. Further, insofar as direction number 2 and 3, as mentioned above, is concerned, the same has to be maintained till section 12 of DV Act of the application is decided afresh, while affording opportunity to shown.
My lord.
So insofar as 2 and 3 is concerned, I have not touched. I have said that you keep on complying 2 and 3, direction number 2 and 3, that is 10,000 rupees house rent and 20,000 rupees maintenance, and move an application before the 12 court, DV court, and DV court, if varies that order, it's all right.
Though, my lord,
That is pending.
My
So
lord.
if that variation application is pending, you have to comply. As simple as that. What is big deal about it?
No, my lord, as per direction, my lord, you have complained, my lord, that's, my lord, so far is the.
Then you are say that since the ex parte order is set aside, the execution petition can't go on.
No, my lord,
That's not-
my lord,
that's
I
not-
am submitting, my lord, the present petitioner, my lord, as per direction of the Honorable High Court, my lord, the present petition depositing the 15,500 towards on, my lord. Even if, my lord,
No, no.
my lord, this is the suppressing all these things by the opposite party, my lord.
You go and tell all these things before execution petition.
My lord,
So far as
eh,
direction number 2 and 3 is concerned, I have not touched it. Till the variation court, the section 12 court will decide
my lord,
whether it has to be changed, modified, whatever. Till it is modified, you have to.
I pray, lordship, my direction may be given to expedite, my lord, the variation petition since 5 to.
Insofar as this petition is concerned, the only thing is I will give direction to where the variation application is pending.
My lord,
Where is that application
before
variation?
JMFC LR, lordship.
JMFC Bhubaneswar.
Sir, my lord.
LR.
LR, my lord.
That I'll give a direction that he should decide the application.
My lord, within 1 month, my lordship, may.
Madam.
Lords, if I may,
And this is the second round. I'm not passing any order against you. This is the second journey of the petitioner.
My humble one prayer, lordship. Lordship, I glanced in the so far as IA 185 is concerned, my lord. Lordship in 16/12/2025, my lord. My lord, there was, my lord, my lords have directed to pay 9 lakhs, my lord.
That will be adjusted. That will be taken care of. That you have deposit.
My lord, if a lordship may,
if I may.
Wants to submitting, my lord.
Have you deposited or not?
My lord, now I'm as for instruction, my lord, he wants to deposit same, my lord. If lordship may permit, come.
Yes. Yes.
Yes.
Both injuries are simple in nature.
Yes.
Might have been caused by hard and blunt
within 24 hours.
And so far as the truthness of the story, your lordship may kindly come to cross-examination of PW 8.
8, huh?
8.
Yes.
The victim informant. I used to work under Maga Pradhan. What happened? The story is he was watering the field of Maga Pradhan. And by that time, it is alleged that the accused persons came and Maga Pradhan has prior animosity with the accused persons. So they said that why you are watering the land of Maga Pradhan. So there was an exchange of hot word and they assaulted. This is the allegation. Here, your lordship may cross-examination on the 4th line. After the occurrence.
After the occurrence,
I have never gone to the land of Magapadan where the occurrence took place. Then, my lord, the water pump set, which belonged to one Dhadia Pradhan, and he was also present when I was watering the land by using the said pump. That means, my lord, he was also present. Dhadu Pradhan was sitting under a tree at the time of occurrence, and the tree situates 50 to 60 away from the spot. 50 to 60, I was simply guarding the pump set at the time of occurrence.
Cubic meter.
Cubic meter. But said Dhadu Pradhan has not examined.
Okay.
And so far as PW4 is concerned, he was also an independent witness.
4, huh?
PW4.
What is it? Purnachandra boy had taken the pump set from one so
4 and 5 have not supported.
The water pump.
So
he was hostile.
Hostile.
Who is the independent witness then?
No independent witness. No corroboration, nothing. And so far as the injury sustained, the injury, they are working in a field. So there might be some injury on soldier, the soling injury or
No, that's the left side.
Yeah.
He says right side.
But so far as the contradiction part is.
Both are left side, but hand and shoulder.
And one thing, the victim himself said that one Dhadu Pradhan was present. But why Dhadu Pradhan was not
Dhadu was
examined? Not examined.
PW8, na?
Yes. And so far as the IO is concerned, PW9. PW9, your lordship may kindly come to at para number 6. Sorry, Dhodia allies Yogendra Pradhan, he is the eyewitness and stated by the IO and also by the victim. He was examined as PW4. That PW4 is Dhodia. Did not support, and he said in his cross
I examined Dhodia, Yogendra Pradhan.
Yes.
Yes.
Yes, Dhodia and one person Miller. And so far as 4, he stated in his cross examination that cross examination of Dhodia. It's nahi, deina.
It's there. Para 2.
Yes. Yogendra Pradhan. I have never given my palm set on hire. The victim stated that we had hired palm set from Yogendra Pradhan. But in para 3, cross examination of Yogendra Pradhan, he stated that I had never given my palm set on hire to Purna Bhoi prior to the occurrence. Purna Bhoi, the victim, injured, to irrigate the land for which trouble started.
Yes.
So for that land in question, where Purna was irrigating, there is dispute between the owner of the land, Magga Pradhan, and the accused person. So there was my submission before your lordship is that Purna Chandra Bhoi, being a scheduled caste person, is set by the Magga Pradhan, who has prior animosity with the petitioner, appellant. So he was set to lodge a case under 3 SC/ST Act, and so
he have been
3
executed.
SC/ST Act is not is charged, but not proved. Only 323 proved. So this is a clear case of acquittal. His own statement is not supported by that Yogendra Pradhan. He is the vital witness, PW4.
Yogendra.
PW4 is vital because he is the only witness who has to support the case.
Yes.
Injuries are there. Maybe simple.
Injuries are there, but these are the doubtful credentials. Because the injured says that Dharu Pradhan, that is Yogendra Pradhan was
Injured is Purna Chandra
there. He
Bhoi.
was examined. He is the real eyewitness.
Eyewitness, but
He has completely not supported the case.
Not
So,
supported.
except the evidence of the injured, but case is made out basically. The injured witness says, and which is corroborated with the doctor's evidence.
doctor also opined that is simple, but injuries are there.
But my submission is that the land belongs to another person who is not a scheduled caste person. Thus, this Purna Chandra Bhoi, who is a scheduled caste person, the landowner has prior animosity with the petitioner. This is established, the appellant. So this Purna Chandra Bhoi might have been
At the instance of Purna Chandra Bhoi, this case is falsely foisted under SC/ST Act and all, which has been. So that therefore a doubt is being created.
Yes. And there might be some corroboration, then something else, but there is no corroboration at all. And PW4 simply denied that I have never hired my pump set.
But PW8 and PW doctor, PW?
One.
One said blunt injury with slight swelling. Well, they are all working in a field and with hard and blunt materials. So there might be some swelling injury only and nothing else.
The injuries are within 24 hours.
ଲୁହା ଜିନିଷରେ ସବୁ କାମ କରୁଛନ୍ତି ପାଇପ୍ ସେଠି there might be some.
He is a laborer basically.
Laborer.
He is a laborer.
Injured is a laborer.
Even if you upheld it, 500 rupees fine. What is this?
500 and 400 rupees for
427.
427.
900, 1000.
And they have spent 1200 expenses, medicine expense.
ନାଇଁ ସେଇଟା କଣ ସେଣ୍ଟେନ୍ସ ତ ଖାଲି ହେଇଛି
No, just see, what is the 500 for 323
Yes.
and 400 each?
ନାଇଁ for 323 1 month or
427.
427 400. If it is
Okay,
upheld,
fair.
only fine can be.
Total what is the then total fine is how much then? Each क्यों पता होगा?
My consider fine of rupees 500 to each of them in the
No, but why I tell you, there were 2 accused persons.
Yes.
And now this appeal is filed by one.
Each of them less than.
No, just see the impugn order. Therefore, at the end it says that 1500 will be paid to PW8 as a compensation out of the deposit. Whereas there are 2 accused persons in fact. But this appeal is preferred by only one. No. Legality and correctness of judgment also teach to something. No, just see this. There is something. Come to the impugn order. ST case number 254 of 2006. There are 2 accused persons. And in ST case number 415, there is only one, who is the present appellant.
I am concerned in ST case number 450.
What happened to the other case? ST case number 254, 2006.
Whether there is deferred appeal or not.
Wait, there are 2 cases. Huh? How this, there are two cases. What happened to the other one? Not clear.
দুইটা কেন 254 অলগা জি জিআর के समझे
Just check it up in the ST case number 254 of 2006, whether appeal is preferred or not. 254 ST case number 254 of 2006. 2006. That is state versus Vikoi, alias Vikram Pradhan. District. This is the Puri. Not clear. There. No appeal. They have not filed appeal, it seems. Huh? They might have given. Already please. Okay. Note down the name and amicus curiae is appointed. Don't forget appointed is amicus curiae. Heard. Judgment reserved. Yes. Yes. Next.
87.
87. Have you seen? What is this? Huh? PLBC.
My lord.
PLBC. 446.
449 is the appellate appeal.
NRC 446, huh? Yes. Procedure when the bond has been forfeited. Whenever the bond.
449.
Huh?
449.
49.
Appeal from order.
49, huh? An appeal from an order under 446. All order passed under section.
Order passed by session to the so here is the order passed number 446.
187. The order was passed by session. Then it lied to this code only. Appeal is
para 3 page 10 para 3. So 20%. Page 10 para 3.
Page 10.
Para 3. Present petition is the surety.
Surety 30,000 rupees now.
You bring that up. This is the person and it is only source of only 280,000. Thereafter, the other part that to pay deposit of 30,000, that is your punishment.
They have not appeared also, it seems. Nobody knows.
In case the accused would have been appeared, then the crime would have been
Waived.
pleaded.
No, you tell me one thing. Suppose bail bond is given, accused absconded, and these kind of orders are passed. Subsequently, police apprehends them. Then this is maintained. This is maintained.
This is maintained.
Unless he takes them and produce them, this order cannot be found fault with.
He is undertaking. He was giving undertaking.
It is his responsibility.
He can eliminate the
So once PO is declared, then it is police will arrest him or not. That's a different story altogether. But how will you find fault with this?
No, there is no fault.
There is no fault.
The ground has not yet been pleaded in the court petition that.
And he is very casually saying that set aside the conviction. How can you can ask for conviction? Set aside. Procedure when the bond is forfeited, when the report is land. Any bond under the court is proved to be satisfaction of the court by which the bond was taken, or the court which may subsequently find transfer, or the court may issue the courts of the court the ground of such may call for any
Your Lordship, then page 7.
penalty thereof.
The initial order issue.
Huh?
The initial order when the bank bond was prohibited, so for that issue. In that context, the present appellant would have been given any satisfactory cause. Why he is unable to.
Therefore, 10,000 to 30,000
Then the
3 times.
case initiated accordingly ordered.
Now, what is the how much he can do? Pay the penalty thereof, or to show cause why it should not be paid. 3 times 10,000 rupees was surety.
3 times he is.
Oh, where from he got the power 3 times? The same amount or increased amount? See, he stood the surety for 10,000 rupees. See, only 10,000 rupees should have been. Suppose somebody stands surety for 1 lakh rupees. If the accused doesn't come, then can you increase it to 3 lakhs? Where from the power comes? What is the surety? What he says that if he will not appear, I am standing as a surety for 10,000 rupees. If he can't come, then 10,000 rupees only you can take. What is the reasoning given?
Para 3 page 10.
Yes, there is the record.
Found the vendor investigation for an amount 30,000.
Oh, 30,000. Okay, 30,000 then next. No, somewhere I read 10,000. Okay, 30,000.
30,000. Bail amount 30,000. Page 80 also.
Then section, what you said, section 446 and 449. Section 446 and section 449 appeal. Huh? And he has filed the appeal under which provision? This appeal is not maintainable. What kind of appeal is filed? 449 he has filed. But he's seeking setting aside of that conviction. And now 15 years, this last 15 years this is pending, just imagine. Okay, record his presence. Record his presence because any matter?
Data report mo have item 65, item 76 report.
Wow. The report order. It's payment is 26. Report. Consent to this.
77, 82, 87, 22.
Report. In two cases, we are seeking report.
76,
76,
82 years.
82. Whatever. Huh? Concerned police system को intimate कर दे police system. ठीक है? Yes.
Lordship, on behalf of Mr. Ajay Kumar Nanda, item number 74. Your Lordship, the appellant is about 92 years.
74.
Yes, Your Lordship.
Let's see 74. 74 will be report मांगा भैया. No. Okay. We are asking for report next Thursday.
Lordship, item number, may I please, Lordship, item number 69. Same for status.
69. What is the age of the?
In the time of 2009, 963 age.
2009 to 63. I have report मांगी आपको 69. Report, huh? 69. That matter is report, huh? Today there are 5 matters where report has to come. And we'll see then next Tuesday or let it be Tuesday. Let it be Tuesday. Huh? All the matters let us be Tuesday. If report doesn't come, then we will give another date. Okay. Thank you. Did you file?